Now, what is interesting in this case is that the lawyer for the Chief Justice, Kusi, made the argument that as far as he is concerned, there's been no prima facie determination established by the president, because in his explanation, if there were any prima facie determination, it would have found its way in the contents of the communication between the executive secretary of the president to the suspended Chief Justice, when he captured in that communique that the Chief Justice had been suspended because a prima facie determination had been made. He says the absence of the reasons that informed the prima facie determination meant that the suspension of the Chief Justice is unreasonable and arbitrary. And so he wanted the Supreme Court to make a determination on that particular stance. The case brought before the Supreme Court by Theodore Kofi Atakwote was called, and the argument was no different. Just as in this case, the lawyers of the plaintiff wanted an interlocutory injunction on the committee and a suspension of the operationalization of the warrant issued by the president, because just like the Ghana Bar Association had stated in their open threat to the president that they will go to the Supreme Court because the president did not act according to the dictates of the Constitution when he suspended the Chief Justice. He ought to have laid a constitutional instrument in Parliament, wait for it to mature in 21 days, and that would have given the president the powers to do what he did in respect of his suspension of the Chief Justice. In his view, lawyer for the plaintiff in this particular case also made the argument that the president had violated the law or the Constitution, and so the entire process must be deemed null and void. The Attorney General was represented in this case by the Deputy Attorney General, Dr. Justice Shremsai. He also made the argument that as far as they are concerned, the president has not violated any part of the Constitution, and that he went according to the dictates of the Constitution and found the argument by lawyers for the plaintiff as frivolous and an abuse of the court system. So in a 4-1 majority decision with Justice Asare Darko dissenting, the 5-member panel deemed the applications unmeritorious and dismissed same. Now, this particular panel had Justice Asare Darko, who dissented. It also had Justice Henry Anthony Kofi. It had the Acting Chief Justice, Justice Bafu Boni. It had Justice Yoni Kolendi and also Justice Amadou Tanko on that particular panel. They sat on both cases and came through with the same ruling, a majority 4-1 decision. The full ruling is expected to be out next week.
Well, they have spoken. I will go into conclave with my lawyers and we will advise ourselves appropriately.